Welcome to Military Justice and the Law, presented to you by Bulani Tseu. In this episode, I'll be discussing judicial independence of South Africa's military judges, especially with regards to whether the periods of assignments of our military judges amount to adequate security of tenure. Generally, judicial independence denotes that judicial officers must have liberty or latitude to execute their judicial functions without interference from any other person. Courts and academics respectively agree that judicial independence is the heart and soul of the rule of law in democratic countries. In other words, it is through the independence of the judiciary that human rights and other constitutional principles are preserved, respected, and protected. Where there is no judicial independence, injustice and anarchy prevail. This is perhaps the reason why the former Chief Justice of the Republic of South Africa, Ismail Mohammed, stated that subvert that independence, you subvert the foundations of a constitutional democracy. Attack the independence of the judges, you attack the foundations of freedoms as articulated in the Constitution. And the consequence of that is to subject humankind to injustice, tyranny, and brutality. The Constitution of the Republic of South Africa 1996 is clear that courts must be independent, and no other person, organ of state, member of executive or legislature should interfere with the functioning of the courts. Within the context of the South African National Defence Force, Section 19A of the Military Discipline Supplementary Measures Act 16 of 1999, MDSMA, stipulates that military judges must execute their judicial functions independently and without fear, favor, or prejudice. There are three characteristics of judicial independence, namely security of tenure, financial security, and institutional independence. However, in this episode, the focus is not on financial security or institutional independence. It is on security of tenure with regards to the periods of assignments of our military judges. The MDSMA stipulates that the Minister of Defense and Military Veterans may assign a person to act as a military judge for a fixed period or until the end of a particular deployment or exercise. But the MDSMA is silent on the duration of these assignments. It is left to the minister to decide what is the appropriate duration for the assignment. In the past, military judges were assigned for 1 year at a time. However, in recent times, assignments of our military judges last for 2 years. At the expiration of that period, the minister may choose to assign or not assign a particular military judge. So a military judge who is not assigned will ordinarily serve in other capacities within the Defense Legal Services Division. So he can either be assigned as a prosecutor or defense counsel, whatever the case may be. These periods of assignments were a subject of a constitutional challenge in O'Brien and others versus the Minister of Defense and Military Veterans and others. The High Court in that particular case reasoned that the periods of assignment rest within the discretionary powers of the minister. So the legislature in that regard has adequately addressed tenure. And the court found that there is nothing wrong with assignments for a shorter period, taking into account the exigencies of military service. Because the military judge, based on his exigencies, may be assigned to serve in other capacities. So essentially, the High Court said, well, the practice of assigning military judges should continue. There is a problem with that decision, at least in my view. It must be mentioned that military judges are accountable to the member of the executive, the Adjutant General. I've mentioned elsewhere that military judges must complete 120 cases in a financial year. And military judges who do not meet those prescribed targets may find themselves in a situation where the Adjutant General will not recommend that they be reassigned as military judges. There is evidence that some military judges find their assignment as a military judge to be the crowning moment in their careers. Therefore, it is a prestigious occasion, so they will want to remain as military judges. So essentially, this is not to impugn the integrity of serving military judges, but it is to highlight that in order for a military judge to basically make certain that he or she is reassigned, he may basically want to finish these 120 cases at all cost, therefore sacrificing justice both for the state and for the accused. That possibility exists. In this connection, I echo what was said by one academic, Eugene R. Fidel, when he stated that a judge who does not know with precision what will happen to his assignment once it expires is a sitting duck for improper influence. In other words, that judge may want to do things that are unscrupulous in order to basically position him or herself for further reassignment. There's a problem here. In this regard, one must therefore compare the periods or the tenure of our civil and judicial officers with that of our military judges. Magistrates serve until retirement, or may serve until retirement, and that retirement age is 65 years. Judges of the High Court and the Supreme Court of Appeal may serve until they are discharged from active service. Justices of the Constitutional Court serve for a non-renewable period of 12 years, or up until they reach the age of 70 years, whichever comes first. In my view, civilian judicial officers enjoy adequate security of tenure. One is mindful of the fact that judicial independence is an elastic concept, so I cannot expect the independence of the higher courts, for example, the Constitutional Court, to be safeguarded in the same manner as that of the lower courts. But be that as it may, there must be some resemblance. In other words, in my view, if you appoint civil and judicial officers, why assign military judges instead of appointing them? Because the problem with the security of tenure of military judges lies in these two concepts, assignment and appointment. Assignment and appointment are often used interchangeably, but the meanings to be attached to these concepts differ to a certain degree. Oxford Dictionary defines the concept to assign as to give a piece of job or work to somebody else. Ordinarily, once that piece of job is done, that person may be assigned elsewhere. However, to appoint is to select a person to fill an office. So a person who is appointed remains in office even if a particular job that he was doing is finished. So in my view, an appointed person enjoys adequate security of tenure than the assigned person. Based on this, it is my suggestion that it would be best to basically follow suit and appoint the military judges instead of assigning them. The practice of appointing military judges has been done in other countries. For example, New Zealand. In New Zealand, military judges are appointed and they may serve until they reach 70 years of age. However, a chief military judge may serve until 75 years of age. In Canada, military judges were once upon a time appointed for a renewable period of 5 years. But since the enactment of the Security of Tenure of Military Judges Act of 2011, military judges of Canada serve until they attain retirement. In other words, until they reach the age of 60 years. So in this episode, I've made mention that judicial independence is very important in our constitutional democracy. And judicial independence applies also to military courts. I've outlined that one of the characteristics of judicial independence is security of tenure. And I've made it clear that security of tenure of our military judges with regards to their periods of assignment leaves much to be desired, because in my view, an assignment of 2 years, for 2 years rather, does not amount to adequate security of tenure. And the consequence thereof is that military judges may tend to strive to meet the targets at all costs, because in any event, some of them view their time in the bench as a crowning moment. Therefore, one of those prestigious occasions. So essentially, I've outlined that it would be best to basically follow suit and mirror the manner in which our civil and judicial officers serve in terms of the duration of their appointments or tenure. So I trust that you enjoyed this episode. And whoever has not subscribed, please subscribe. In the next episode, I'll be discussing another component of security of tenure, which is the removal of a serving military judge from the bench.